Good morning, this is your Kelso Report for Tuesday, July 31st. I'm your host, Clark Kelso. We begin with the Ninth Circuit in an environmental law decision in League of Wilderness Defenders versus the United States Forest Service, when the Ninth Circuit ruled in favor of the Forest Service's experimental forest thinning, fuels reduction, and research project in the Deschutes National Forest in the eastern Cascades of central Oregon. The project allows logging and controlled burning on roughly 2,500 acres of the Pringle Falls experimental forest. The purpose of the project is twofold: to reduce the risk of wildfire and beetle infestation, and to conduct research on ponderosa pine forest management. The League of Wilderness Defenders Blue Mountains Biodiversity Project filed suit against the Forest Service, alleging that the agency's environmental impact statement for the project fails to comply with the National Environmental Policy Act. The District Court granted summary judgment in favor of the service, and the Ninth Circuit easily affirmed. The whole point of the project was to conduct an experimental management methodology in a forest that was specifically set aside by Congress as a forest for conducting management experiments. While experiments still must be supported by an environmental impact statement, the experimental nature of the project alters the court's expectations of what it expects to see in the EIS. As the Ninth Circuit concluded in this case, the service proposes a forest management research project in an experimental forest specifically set aside for such study. The EIS considers in detail a reasonable range of alternatives that would fulfill both of the project's goals by reducing the risk of wildfire and beetle infestation, and by addressing 6 specified research objectives. The EIS was adequately supported by scientific data and took a hard look at the significant impacts of the project. That is all that is required in this context. Next, a health law decision. We see in International Rehabilitative Sciences versus Sebelius a pretty good example of the future of healthcare decision-making in this country. The Department of Health and Human Services, the agency that administers Medicare, denied Medicare coverage for the Bio 1000, a piece of durable medical equipment used to treat osteoarthritis of the knee, on grounds the device had not been shown to be reasonable and necessary for the treatment at issue. The supplier of the device challenged that decision as arbitrary, capricious, and not supported by substantial evidence. Well, the Ninth Circuit joined the Fourth Circuit in holding that the Medicare Appeals Council's coverage denials for the Bio 1000 were not arbitrary, capricious, or unsupported. In particular, after reviewing the scientific studies submitted by the Bio 1000 supplier, the Medicare Appeals Council reasonably concluded that those studies failed to show the device was more effective at alleviating knee pain than a TENS device costing 80% less. And the Medicare Appeals Council reasonably concluded that the studies failed to show that the device was effective at regenerating cartilage in humans. Now, it sounds to me like this is the right decision, although I suppose a healthcare law critic could assail the decision on grounds it was made by a government panel instead of by the market. Why should the government pick winners and losers? If the TENS device is so much better, won't the market make the right decision? Well, of course, a partial answer to that might be that maybe the pharmaceutical and durable medical equipment markets are not exactly the models of competition that they are made out to be. In any event, a good example of what we're likely to see in the future. Next, we turn to an exhaustion of remedies problem. In Bullock versus Berrien, the Ninth Circuit handled an issue of exhaustion of remedies in the context of a claim of employment retaliation, ironically, against the Equal Employment Opportunity Commission. The plaintiff, a former employee of the EEOC, believes she had suffered employment retaliation after she had filed a disability discrimination claim against the EEOC. Prior to filing her suit in federal court, she filed an administrative complaint that was adjudicated by an administrative law judge. After the ALJ denied relief, she filed an optional administrative appeal within the EEOC. She then subsequently withdrew her appeal without waiting 180 days, as specified in applicable regulations, and she instead filed suit in district court based on the same claims she asserted in her administrative complaint. The district court granted the government's motion to dismiss on the ground that she had failed to exhaust her administrative remedies. She needed to wait for the 180 days to conclude, even though she tried to withdraw. The Ninth Circuit reversed, holding that an aggrieved employee, subject to the procedural rules of Title VII, exhausts her administrative remedies by filing the formal complaint for adjudication by the ALJ. Nothing more is required, particularly since the internal administrative appeal is optional. The agency suffers no serious prejudice when the petitioner files and then withdraws the administrative appeal, so long as she has filed suit directly in federal district court within 90 days of receiving notice of the original ALJ agency action. In short, the decision to file the optional administrative appeal is not irrevocable and does not create a new and additional exhaustion requirement. We turn to the California Supreme Court. We have three cases from the court yesterday. First, a death penalty decision. The defendant in People v. Tully was convicted of the 1986 murder of a woman and assault with intent to commit rape. The jury found true a special circumstance that the murder was committed in the commission of a burglary, and as to both counts, the defendant used a dangerous and deadly weapon. It only took the California Supreme Court, in this case a whopping 161 pages, unanimously to affirm the conviction and the death sentence. Next, a right to jury issue that was before the California Supreme Court in People v. Barrett. The issue was whether the target of a civil commitment proceeding under Section 6500 of the Welfare and Institutions Code, that is, a person who has been diagnosed with medical retardation and other mental disorders, and who is increasingly engaging in violent behavior, the issue is whether that person must personally waive the right to a jury, or whether it is permissible for the target's counsel to waive the jury. Following her commitment, the target in this case appealed, alleging that permitting counsel to waive the jury violated due process and equal protection. As the majority noted, the Section 6500 process is initiated and proceeds from the outset on the basis of strong evidence that the individual facing commitment has cognitive and intellectual impairments that would prevent him or her from making a meaningful decision whether to invoke or waive the right to jury trial. The person's rights and interests are protected by the state's statutory obligation to provide counsel in Section 6500 proceedings. And so in these circumstances, the California Supreme Court held that both due process and equal protection are satisfied by a rule requiring only counsel to make the tactical decision whether to seek or waive a jury. Next, a case involving a propensity evidence. Pursuant to Evidence Code Section 1108, Pattern Jury Instruction, CalCrim number 1191, explains to a jury that it may consider a defendant's uncharged sexual offense as evidence of his or her propensity to commit a charged sexual crime. Well, in People v. Villatoro, a majority of the Supreme Court held that CalCrim number 1191 could properly be modified to permit the jury to consider the defendant's charged sexual offenses as evidence of his propensity to commit the other charged sexual offenses. Now, the majority's decision here is supported by the plain language of Section 1108, which provides that in a sexual offense case, quote, evidence of the defendant's commission of another sexual offense or offenses is not made inadmissible by Section 1101 if the evidence is not inadmissible pursuant to Section 352, close quote. As the majority noted, the statutory language does not distinguish at all between charged or uncharged sexual offenses, and instead simply refers to another sexual offense or offenses. So in light of this language, the majority held that the jury instruction, which permits the jury to consider the defendant's other charged sexual offenses as propensity evidence, was permissible. We close today with an arbitration decision from the Court of Appeal in Sparks v. Vista Del Mar Child and Family Services. The Second District took a close look at the enforceability of an arbitration provision contained in an employee handbook. Even though the employee acknowledged that he had received the handbook, a majority of the Second District held that the provision was not enforceable and was unconscionable because it was included within a lengthy employee handbook. The arbitration clause was not called to the attention of the employee. The employee did not specifically acknowledge or agree to arbitration. The handbook stated that it was not intended to create a contract. The handbook provided that it could be amended unilaterally by defendant, and thus rendered any agreement illusory. And the specific rules referred to in the arbitration clause were not provided to the plaintiff. Now, this is a pretty good list of reasons for both procedural and substantive unconscionability. And so I think this decision is probably going to stick, since it doesn't appear to single out for unconscionability purposes all arbitration clauses in employee contracts, a rule that almost surely would be contrary to United States Supreme Court precedents. This is a good example of how to analyze an arbitration clause in an employment context. And that's it for today's Kelso Report. Have a great day in the law.